Welcome to the third episode of Risk Settlement's podcast, Alternative Litigation Strategies, which features interviews with key leaders in the commercial litigation industry. I'm your host, Kevin Skrzysowski, one of the directors here at Risk Settlements, and today we'll be discussing developments in biometric information privacy laws. Today, I'm happy to be joined by our guest, Christopher Ward, a partner and labor and employment attorney in the Chicago office of Foley and Lardner. Good morning, Chris. Thank you so much for joining.
Sure. Thanks for having me. My pleasure.
Great. So, Chris, to start, of course, Illinois was the first state to enact a biometric information privacy law, commonly referred to as BIPA. What exactly does BIPA regulate, and what lessons are other states drawing from the Illinois law?
So I guess the quick summary on what BIPA does is impose several mandatory requirements that or they're essentially notices and disclosures that need to be provided to users if you're going to collect biometric information. You got to give them notice that you're doing it. You basically got to give them notice of the retention policies, the destruction policies, and the like. And then the failure to provide these disclosures, if you fail to do so, opens up essentially a mandatory penalty scheme, either based on negligent violation of the statute or willful violation of the statute. In terms of what other states are learning from BIPA, it almost sounds like a misnomer. Obviously I deal with defending these kinds of cases. And, as other states are implementing these kinds of statutes, for the most part right now, they're kind of copying what Illinois has done. And I think this is a space that needs the regulation, but I don't know that the approach that BIPA has taken that the other states are following is necessarily the right way. It's really created this sort of gotcha litigation climate where it's a rush to file these cases, even when, there hasn't actually been a data breach or any issue where someone's biometrics have been disclosed in a breach or anything. It's just created a sort of a class action climate. And I'd like to see the states regulate this in perhaps a little bit more intelligent way, but I'm just the messenger.
No, that's a good point. So, I mean, breaking it down a little bit, do you think then that the focus should be, or where do the concerns lie? Is it on like the acquisition, or should it be on the disclosure of the biometric privacy information, or both, or waiting until there's a breach?
Well, I think it should be on both, right? I have no qualms with regulating and creating protections if you're going to collect or acquire this information, right? I think that aspect of the statutory mission is totally appropriate. And there needs to be some enforcement mechanism for that, right? There's got to be some teeth for it, because if there's no consequence to failing to comply with the statute, then there's no, motivation for a lot of people to do what they're supposed to do. The question is, what is the consequence, right? And right now, this mandatory penalty scheme, even when there hasn't been a data breach, and, if you take my biometric information and have done nothing but fail to actually tell me that you're doing what the statute has done, the question I have is, have I really been harmed? Has somebody really been harmed when, yeah, you haven't told me that you were due, but I haven't suffered any loss of my own confidentiality or anything like that. So what I would like to see is probably more focus of the penalty scheme on the data breach side, while
right.
There still is an enforcement mechanism for the failure to follow proper acquisition protocols. And maybe it's you file a case and there's automatic fee shifting, and you can get an injunction plus a one-time penalty or something like that of XX dollars. But the way that this is shaping up right now is it's just a gotcha statute, right? Like, you fail to notify me that you're collecting biometric information, and that in and of itself creates the seven-figure liability. That's all, and that's the right. Concern I have is it becomes this, the motivation right now is for people to file as many lawsuits as they can on this stuff whenever they think there's a biometric issue, because it's a money grab at the negligence side. And yeah, BIPA's been on books for a long time. There's probably going to be my counterparts on the plaintiff side saying, well, but employers and companies aren't doing what they're supposed to do. And I agree with that. This is an issue that needs to be addressed. But the litigation climate itself, it's really making all the lawyers rich, and instead of protecting people. And the motivation should be much more about actually addressing the problem instead of, creating a gotcha class action climate, if you ask me.
No, I understood. Let's talk about that a little bit more. So I know you recently wrote an article about the developments in Biometric Information Privacy Act, and in that article, you had mentioned that there's about 27 other states with BIPA modeling legislation, and within some of that pending legislation, they note that a violation of the statute would constitute a rebuttable presumption of harm to the individual. And in a lot of this pending legislation, there's significant penalties. I mean, what are the range of damages that some of these states are contemplating when they're considering allowing private rights of action like Illinois is?
The recent New York and Maryland laws essentially follow the Illinois BIPA, it's the 1,000, 5,000 scheme. But it's all sort of the same thing. It's fee shifting, it's liquidated damages. And the question where, Illinois has come down is that the mere failure to notify, the mere failure to give the disclosure is deemed enough to file a case. It's deemed a harm itself. And I sit there and go, how do you square that with Spokane, where, the Supreme Court has said repeatedly, like, there has to be some tangible harm. And that might be another area where I'd love to see some of these other state legislators think a little harder than what Illinois has done. Is what actually constitutes a harm, where, if we want to compensate people who've been damaged, then, have they really been damaged? And, I'm very biased on this one side, right? Because I look at this and say, what I'm doing is I'm defending a lot of cases where nobody's actually been harmed. And honestly, the only people who are winning are the lawyers, including me, quite frankly, because it's giving us work to do. But
sure,
I'd love to see the states take a focus on what is actually the problem itself, and there's got to be a better way to do this that I think gives people the incentive to do what they should be doing, which is disclose to people that they're collecting or using biometric information. That does create an enforcement mechanism for those who fail to do what they're supposed to do, but that at the same time doesn't incentivize this gotcha class action litigation climate.
No, understood. So I think the next state, California already has a BIPA law, but I don't think it begins to apply to employers until January 1 of 22. I mean, what impact do you see from that? Or do you see any of the other pending state legislation taking into account some of the concerns that you have?
I do not really see some of these other states yet taking into account these concerns. Most of the other states are modeling their statute basically on BIPA.
Yeah.
What impact do I expect to see on California come January 1st, 2022? Another run to the courthouse. There's definitely, that's been the wage and hour environment in California for going on close to 2 decades now, and really started in sort of the early 2000s with a desire to file as many of these class actions as possible. And it's just keep going. And I think the plaintiffs bar, at least the smart ones in California who are opportunistic and enterprising, are watching what's going on in Illinois right now and just waiting for January 1 to come around so they can start filing these gotcha cases themselves.
Okay. Speaking on a run to the courthouse, and I almost hate to even mention this because I feel like we're emerging from this and we're returning to a new normal. But due to the COVID-19 pandemic, I know a lot of employers and schools, they turned to, everybody had remote work, we had remote learning. Businesses were using facial recognition. They were using other forms of biometric information as a contactless way to track employees' time or do things like ensure access to the building or access to information. So as this legislation is passed in more states, are we going to see a surge in cases, or did we see a surge in cases in Illinois stemming from some of the business practices that were instituted during the pandemic?
No, the BIPA surge really predates the pandemic by a number of years. And remember, BIPA, it's this odd thing. BIPA is not a new statute. It's been on the books for, I don't know the exact, but it's more than a decade. It's just at some point, I want to say in 2018 or thereabouts, somebody figured out, hey, with biometric timekeeping and finger scan technology, this is an opportunity. And then the climate just exploded from there. So this was going on for a number of years before the pandemic. That said, the pandemic has just really, I think, accelerated certain technology use that was going to happen anyway.
Right.
There is a business reason to keep implementing and developing this technology. As a consumer, it gives me certain things that I like. And as a business, it creates efficiencies and opportunities. biometrics are happening and they're going to happen more and more. So I don't have a qualm at all with the fact that we're legislating and regulating this. I think we need to be because there are concerns about data breaches and whatnot. So yeah, I do think you're going to see a lot more use of this type of technology across a lot more platforms. And I do think you're going to see a lot more litigation as a consequence because inevitably, as the volume of this technology increases and as the legislation around it increases, that's going to increase the litigation that goes with it.
Yeah, I agree. It's just inevitable as the technology will continue to evolve and as they tweak it and as they go through the different iterations and machinations of that, you'll have litigation occur as just a natural spinoff.
Sure.
So, in terms of your litigation strategy, when you're thinking about your approach to a specific matter, what are some of the factors that you consider when you're deciding whether to move for a motion to dismiss in a case versus possibly positioning it for summary judgment and or trial?
Sure. And this is my own personal philosophy that's not limited to BIPA. It's all cases. Like I don't generally like filing motions to dismiss unless they're slam dunk winners, right? Like winners where you think you've got a 75% chance or better, not only of getting the motion granted, but getting it granted without leave to amend. Because otherwise, yeah, you get a motion to dismiss granted, but with leave to amend, you do two things. Like you educate the other side on the weaknesses of their case right away and give them an opportunity to fix it and prepare for it, which undermines your own defense. And B, to be entirely truthful, I think you spend the client's money without really getting anything for them. If you're just spending time to educate the other side on how to make their case better. So unless I can look at a case and say, I've got a clear statutory defense, and I just had one of these, for example, where, the client was a contractor with a state or local government actor. And so under Section 25E of BIPA, they just have a categorical exclusion from the statute's coverage. In that circumstance, I said, listen, if you don't go away, I'm going to file a motion to dismiss. And the case went away. We didn't even have to file the motion because it was that clear that this was just not a good case. But short of those circumstances, to me, especially in an emerging legal environment like BIPA still is, you want to flesh out legal issues at summary judgment if you can, right? Like if you think you've got a legal defense, but it's going to require an interpretation of the statute, don't do it at the motion to dismiss stage because a court is inevitably going to look at that and say, well, right now, based on what's alleged, I could see this being a potential violation. And I don't necessarily have to get into the weeds of the full interpretation of what this statute might mean against a locked down set of factors. And that creates, honestly, a lot of bad law for me and for, the companies who are defending this case is because now you have an interpretation of the law in a context that a court is inclined and should be inclined to interpret generously to the plaintiff. Whereas you lock down the story at summary judgment and you sit there and tell a court, listen, here's the actual situation that is happening here. And this law should not apply to this situation. And you don't have to sit there and wonder what could happen in the case. All you have to do is say the law says it's unlawful to, collect and it's unlawful to possess. And I'm showing you categorically here are the facts that we did not collect and we did not possess. Now you're in a much better circumstance to get the court to interpret the law, ideally the way you want to, or if it doesn't, have an automatic clean appeal because you've made an interpretation of law on a closed set of facts. So, I get that clients want to get rid of cases as quickly as possible. And that's why for some, the idea of a motion to dismiss sounds attractive, but I honestly think it's a bit of being penny wise and pound foolish because it's a myopic view of what your actual legal spend should be. And it's one case instead of the environment itself. So that's just my own personal philosophy. I know a lot of people think differently, but I'm always looking at the big picture. How do I solve the client's problem, both in this case and against the bigger picture, to get sort of the biggest bang for the buck?
And I think that's a very interesting and a very wise defense counsel strategy. And I think that's why when we did some research across just nationwide dockets looking at different natures of suit, not just BIPA, but other types of class action matters. And we found that the large majority of all motions to dismiss are denied. And so to your point, I think it's a stage in the process that some people consider to be like a perfunctory stage. Like we have to go through this. And they're not thinking as you articulated about perhaps passing on that dispositive motion stage and focusing on the motion for summary judgment. Very interesting.
I just don't think clients get very much value most of the time from, and that's always what I'm trying to figure out is it's winning is great, right? You always want to win. You always want to solve the problem as quickly as possible. But sometimes really the solution is it takes a little bit more. And so by spending money on something that doesn't meaningfully advance the case to resolution, you're not giving a client any value.
Right. So speaking of spending money, you had mentioned some of the statutory damages, 1,000, 5,000. I think when we look at a lot of statutory class action matters, there's some pretty significant statutory damages that, this is pretty high. You see, 500, 1,500 in TCPA. They can add up really quickly. They can be catastrophic or daunting for any size business. But, over the past couple of months, we have seen, massive, significant settlements. I think Shutterfly, we saw Facebook, which had 652 million, TikTok with 92 million. What lessons can be gleaned from some of these notable big dollar BIPA settlements?
Yeah, I think the lesson in BIPA is the same lesson that you see anytime you introduce a massively new technological use into an environment, right? And you saw this like with Uber and Lyft and rideshare and all this stuff, where it's like you've got all this amazing technology that really helps things become more efficient. In BIPA, using finger scan technology is very efficient, and it really eliminates time clock abuse and things like that. So there's great uses for this technology, but the lesson at all times is when you're really excited about a technology, think really hard what the trapdoors are going to be too with it. Right? Like, don't be so fast to implement the technology that it sounds great that you forget to look at the risk that goes with implementing something totally new into a new environment. When we went from time cards to punch clocks, and now suddenly you're introducing a new technology. It's a great change, but it obviously has come with some big problems too. That I'm amazed that BIPA's on the books for 10, 15 years, and for almost 10 years nobody was filing these cases. But finger scan technology had been in use for a long time. It took one person to put this together and say, hold on. So I think that's the lesson. It's just don't be so excited about implementing new technology that you forget to manage the risk along the way.
Yeah, well, almost ironic that the legislation came before the technology.
Yeah.
Right?
Well, okay, the legislation was in direct advance to a data breach in a financial sector. It had nothing to do with timekeeping, right? It's just one of those things that it just so happens that you leverage a new technology into a new arena. In this case, it was mostly timekeeping, and nobody really thought through the issues with that. And Illinois was the only one that really had this statute. Washington has a statute that covers biometrics, and Texas has a statute that covers biometrics, but neither of them have any real teeth to them. Illinois is the one that's got teeth.
Yeah. So in terms of, as you mentioned, like the importance of assessing the risk and ensuring that your clients are compliant with all these ongoing developments in biometric privacy legislation. And as we've discussed, the potential for punitive damages and attorneys' fees and massive settlements. How do you counsel clients to try to be compliant with these provisions? I was once speaking with an attorney with respect to California wage and hour law, for example, and they said, no matter how hard you try and how hard you try to counsel your client, it's exceedingly difficult to fully comply. Is the same true for biometric information privacy laws?
So I have a lot of sympathy as a California wage and hour class action lawyer as well. And I definitely share that view that, 100% compliance is very, very difficult because you're depending so much on people and you're depending so much on employees themselves to do what they're supposed to do, right? BIPA is different. Honestly, complying with BIPA is not that hard. And, same thing with the Maryland statute and the New York statute, at least at this point. It's just, if you're going to use a biometric timekeeping system, you need to have a disclosure policy, and you can make it a term and condition of employment. And if somebody says, no, I'm not going to use the timekeeping system, I don't consent to this, you don't have to give that person a job, And so for me, it's, it's been very simple. It's, anytime I talk to clients, that's, and especially when I'm getting to know a new client, that's one of the things I'm always like, just, hey, how do you do your timekeeping? In part because, I'm assessing it from a wage and hour perspective, but I'm also assessing it from a BIPA perspective. And, for years, my long-term clients that, use biometric timekeeping across the country have had a notice and consent policy across their entire enterprise, not just for Illinois employees, because, the message has been, listen, right now, this is an Illinois problem, but this is not going to stay confined to Illinois in the same way that like California is very often on the leading edge of changing wage and hour practices, but the rest of the states often follow suit. So, the idea is don't put your finger in the drain, just create a whole new bathtub that isn't leaky. If you're going to roll out a solution for something and to address an issue in one state, unless it's unlawful across the country, you might as well do it across your entire enterprise, because you're building a system of compliance that is already nimble instead of reactive.
I agreed. I think that's great advice. Certainly. I know we're getting close to running out of time. I had one more question for you on the national level. The National Biometric Information Privacy Act. It's been pending in the Senate for almost a year now, August of 2020. Do you have any sense of what its chances are of becoming a law? And is there anything that we should look for from that in the near term?
I'm not one of those people who have my ear to the ground. I will tell you, I'm generally cynical about things getting done at a federal level right now.
Right.
And some of that is, it's not because of partisanship or whatever. It's just on the priority scale. I think this is probably low, and you can kind of tell the NBIPA has been sitting since August with no movement whatsoever, because Congress is just focused on other priorities. And I'm not here to say that that's right or wrong. I'm not holding my breath for a national biometric statute just yet. At some point, will it be, as this technology continues to advance? Maybe, but on the other hand, there's been a lot of wage and hour stuff that, quite frankly, should have been handled at a national level a decade ago based on rideshare technology. And we're still trying to deal with Uber and Lyft under statutes that were passed in 1930,
Right.
When everything was a corporation, there was no such thing as an LLC at all. I mean, I'm not a corporate lawyer, so I don't know that that's actually true, but it was passed at a time when the world was just different. And now we're still applying old laws to new systems, and it's due for change. Like it's due for change, but that change hasn't happened because there's just not enough focus on it at a national level. So it's being left to the states to handle.
Yeah. I was going to say then, I guess then in the near term, with all of the ongoing developments, the focus should be on, all the states' laws. And again, as we've discussed, with all of the massive potential exposure, as you had mentioned earlier, the best practical advice is really for employers and businesses to remain very closely engaged with their outside counsel to ensure that they are compliant.
Well, and especially in this arena, right? Like the biometric arena, as I said, like compliance here so far isn't very hard. It's just being aware and understanding the risk. This is not a $1 million piece of legal work that you're asking for. It's, hey, assess what we're doing and help us roll out a solution. But it's more about thinking proactively instead of reactively. And that's the relationship I'm always trying to develop with my clients, is that, I'll handle your litigation, but what I really want to do is I want to be a partner in making your business better. I want you to see us as being valuable because we're looking to help you, solve the problems that are coming, not solve the problems that have matured. And so the big issue and the takeaway maybe is when you have something like a BIPA where compliance isn't that hard, it just really does show you the value of having a proactive relationship with your counsel.
I agree, Chris. I think that was the main takeaway of the day, and I think you nailed it. So before we go, is there any programming or publications available for you or your firm regarding the biometric information privacy litigation, or any other areas of commercial litigation that we can check out or that we should look for?
Actually, I thanks so much for the opportunity to say so. Yes, Foley and Lardner's Labor and Employment Practice hosts an annual Labor and Employment Summit in September in Chicago. We do it at the Chicago House of Blues. It's very laid back and casual while being very informal and fun. And that is going to be on September 23rd. 2021. It'll be in person, where we are obviously watching the developing health concerns and safety concerns. So we're keeping seating limited. But if anybody who's listening is interested and wants to attend, they can definitely get in touch with me. My email is just cward, CWARD, @foley.com. Let me know your interest, and we'll see if we can maybe get you in. But it's our signature event. It's coming up, and we'll be talking about privacy and L&E issues at that event.
Sounds like a great event. Terrific.
Yeah, it's lots of fun.
Okay, good. Well, I think that's about all the time we have for today. Chris, it was a pleasure having you as my guest. Thank you for your time. You provided a lot of really valuable insights that you shared with us and with our audience. Thank you.
Yeah, my pleasure. Thanks for having me.
All right, great. And I want to just also quickly thank the audience for listening. If you'd like to hear more, please be sure to follow us on Apple, Spotify, or anywhere you listen to your favorite podcasts. If you would like to listen to a recording of today's program, or you'd like to learn more about some of the litigation and settlement risk transfer solutions that we provide, including solutions to transfer settlement risk and Biometric Information Privacy Act litigation, please visit the Risk Settlements website at www.risksettlements.com, or you can reach out to me directly at kevinis@risksettlements.com. Thank you for listening, and until next time.